Yes, good afternoon to everybody. Welcome to the today class, and that is we are dealing about the nuisance, the continuation. Yes, I posted something on the screen, and any participant can unmute and read what I posted on the screen. Anyone, so that I could know that you are with me and I am with you. Yes, anyone can unmute and read what I posted on the screen. Are you hearing me? Please say, are you hearing me? Please say, are you hearing me?
Sir, yes, sir.
And could you see the screen which I posted on the screen?
Yes, sir.
What is that
Namaskar.
I posted? Can you read?
Sir, Namaskar. Sri Konda Lakshman Bapuji Jayanti Nedu, 27th September 2021. స్వాతంత్ర సమర యోధుడు తెలంగాణ పోరాట యోధుడు ఆచార్య కొండా లక్ష్మణ్ బాపూజీ జయంతి సందర్భంగా ఆచార్య ఆ దార్శనికుడికి ఘనంగా నివాళులు అర్పిస్తున్నాము. ఆ మహనీయుడి ఆశయ సాధనలో తెలంగాణ ప్రభుత్వం పునరింకితమవుతుంది. ప్రొఫెసర్ డాక్టర్ మహమ్మద్ సాహెబ్ హుస్సేన్.
Yes, and he is such a personality that we will say the father of the Telangana also. Somewhere that I read, he is the father of the Telangana. So his name is Sri Konda Lakshman Bapuji, and today is the Jayanti of him. And this is because of him that Telangana got it, and he's also participated in the independence also. That what I read today. Anyway, that what I want to say is, yes, you are with me and I am with you. Then let us go to the point of our study. There is the nuisance. In the nuisance, we have covered at least up to that certain extent. Now I will show you the what extent that we covered it. Yes, here you could see it up to this extent we covered the and these are the following the factors are material in deciding whether the discomfort is substantial or not. When you say the discomfort is substantial, one is the degree of the intensity will be taken. Number two, the duration of the frequency, duration or the frequency. Number three, locality. And then number four, the mode of use of the property. So the best case law is Radheshyam versus Guru Prasad Sharma. That was the case law. It was held by the Allahabad High Court that a permanent injunction may be issued against the defendant if in a noisy locality there is a substantial addition to the noise by introducing the floor mill, materially affecting the physical comfort of the plaintiff. Suppose if the residential locality would be there, naturally in the residential locality some decibel of the sound can be permitted. But if it exceeds over there, then your ear cannot hear that much sound. Like they say, 70 to 75. Okay, 70 in the night time and 75 decibel in the daytime. Generally, it will be taken where your ear can be permissible to hear such a sound. If the continuity is more and more than that, it will be there. Naturally, you will get the pain in the ears and you will get the headache also. So, in addition to that, the floor mill was added over there that also increased the sound, and that's why the physical discomfort the plaintiff filed it because the decibel which is produced over there is more than the 75 to 80 or 85, and that is the discomfort was there, and hence the injunction will be issued over there. So that is the reason the quantum of the damages in private nuisance does not depend on the number of those enjoying the land. And the question, it also follows the only person entitled to sue for loss in anonymity value in the case of the diminution of the land is the owner or the occupier. Whether he is the owner or the occupier, it doesn't matter. But mostly the owner will be taken because he will feel the more discomfort. Either discomfort for the moment or discomfort for the long time. It doesn't make any difference. Discomfort for a while also, discomfort for a long is the nuisance is the nuisance. Thus, persons merely residing with the owner but having no right in the land. Suppose somebody is staying, like the wife and the children have no cause of action in nuisance. Where if the owner generally that we will take into consideration who is enjoying the land, of course they are the part of it. After the owner has to file the case for the discomfort what he is feeling, not the guest and those who are staying with him also what it is stated in this case law. Well, let me see the Boomer et al. Versus Atlantic Cement Company. This case, let's say the plaintiff claimed that the dirty means soot and smoke and vibrations coming from the defendant's cement plant caused injury to the property, to their property. The property owner sought the damages and an injunction to close the plant. The plant already employed the best pollution control technology. But here they said is the plant would be there, and if the plant would be there, not there, then the many people will lose the employment. So the court addressed the economic consequence of the injunction and the effect of the nuisance. The court weighed the economic effect of the closing the plant against the harm to the individual plaintiff land and concluded that the cement company could pay the permanent damages in lieu of an injunction or closing. So they will pay the permanent damages like the polluter pays. Pollutant pays, that the rule would be applied over there. This case illustrates the limitation of the private nuisance law to remedy the pollution. Courts typically balance the equities and hardship. Suppose the more pollution would be there and the public at large would be affected over there, then the plant permission will not be given. Of course, the plant permission is given because they employed the pollution control technology, and hence pollutant pays rule will be applied over there, and some compensation will be paid in the permanent form. The private nuisance don't always outweigh the economic contribution of the polluting entity. So here, closing the plant is a economic way, it is not a feasible, and hence the pollutant pays something to the plaintiff, and thus the case will be decided. But injunctions, in the rare case, the injunctions would be applied because they applied the high technology to control the pollution. Then the Usha Ben versus Bhagya Chitra Mandir, and this case we discussed earlier also. That is the three goddesses, that is the deities, Lakshmi, Parvati, and Saraswati. It is picturized and shown jealousy to each other. So one of the Usha Ben, she felt it very bad, and she filed a case. Her feelings were hurt because they are shown in the movie as the jealousy to each other. The court decided that the film did not hurt any religious feeling, whatever it may be, that the same thing will be picturized over there and synchronized over there, and it's not amount to an actionable wrong. And Usha Ben, he found it hurting. Suppose if he feels that it hurting, then she can decide not to see the film, but she cannot file a case to see that the film would be bad. So if a person is very sensitive for a particular thing, but for others that thing is very normal, then it is not a nuisance. So that is for a sensitive man, it is not a it is a nuisance, but it is not considered as a nuisance because the man is very much sensitive. Action for the private nuisance also lie for the interference with the easement rights and profits, pendere and second rights, which are generally called the natural rights. So in the natural rights also, suppose if you are getting the light, you are getting the air, you are getting the what is say water, which is the natural way. Then if somebody is stopping over there, then it is amount to the nuisance. So the one of the case law, Storian versus Knowles is the case law. Yes, can anybody will read the Storian versus Knowles case law? Unmute and read. Yes. Can anyone read Storian versus Knowles case law?
Storian versus Knowles, 1861, 6H and N, capital N, 454. The defendants were
Yes.
plaintiffs' lands. In consequence of the building did not contribute to the causing of the subsidence was held liable.
The defendant was held liable. The reason is defendant were carrying on a mining operation, and which caused the plaintiff land to subside. So the land would be subsided over there because the mining is there. In consequences of it, damage the factory of the plaintiff. The plaintiff factory is damaged over there because of the mining activity. The court found that the weight of the building did not contribute to the causing of the subsidence. the defendant was held liable. Because when adjacent land, the mining is there, then naturally the building the plaintiff is having, it will take the support from the neighbor's land. That's called the easement. And hence, so if it is not like that, then the land will be subsidence and the building will be collapsed. The defendant was held liable in this regard. And for instance, if you have a multi-story building, very adjacent to that one, somebody will not dig the well, because the area needs the support of his land to your load-bearing pillars. That is the point. That is called the easement. And Section 34 of the Indian Easement Act says also, the removal of the means of the support to which the dominant owner is entitled does not give rise to the right to recover the compensation unless until substantial damage is actually sustained. So naturally, if suppose somebody is dig the well, with that your building was collapsed over there, then definitely that you will get it. Now suppose the building is not collapsed over there, at the time that you will not get it, till the building will be collapsed. Because your load-bearing pillars needs the support of the adjacent land. Let us see the section 25 of the Limitation Act 1963 says, right of easement to light, air, way, water course, and use of water, etc. can be acquired with a prescription if the right has been peacefully enjoyed as an easement of a right without interruption for 20 years. Suppose if you are enjoyed such a right for the 20 years without any interruption, then naturally nobody would obstruct your light, air, and way and water course. And Section 33 of the Indian Easement Act enables a person to bring an action against the defendant if there is a substantial infringement of the easement of light, air, water, and water to use, etc., as stated above. If anybody interfere over there, then it is amount to the nuisance. Yes, now let us see one of the case law is Broadbent versus Imperial Gas Company case law. An injunction was granted. Yes, they have given the injunction because to prevent the gas company from manufacturing gas in such a close proximity to the premises of the plaintiff, a market gardener, and in such a manner as to injure his garden produced by the escape of the noxious matters. So the gas company will be granted the injunction not to operate it because the adjacent man is a gardener and his what is it, plants and shrubs and flowers will be withered and become diminishing value because of this gas and fumes and the escape of the noxious matter from the gas company. So injunction will be granted over there and not to run the plant in that locality. Yes, next case law, Shards Iron Company versus English. In this year, an injunction was granted. Yes, here also injunction was granted. Prevent a company from carrying a calcining operation in any manner whereby the noxious vapors would be discharged on the pursuer's land so as to do damage to his plantation or an estate. So if any noxious gases are emanating from the adjacent land and causing substantial damage to your crop or shrubs or irrigation or flowers or gardening, then you do have every right to file the case under the nuisance and the injunction will be sanctioned to you. So we have the like that case law. Then the last case law that we will see, the Palmer versus Loader case law. In this case, perpetual injunction means permanent injunction was granted to restrain the defendant from interfering with the plaintiff's enjoyment of her flat by shouting, banging, laughing, ringing doorbells, and otherwise behaving so as to cause a nuisance by noise to her. If the adjacent man every time is shouting, banging, laughing, and ringing doorbells and causing the nuisance to you, adjacent land, then you can file a case. Then you will get the perpetual injunction, means permanent injunction, that the adjacent man are not supposed to do such a thing which causes the nuisance to you. Yes, this is the very classical case law, Sturgis versus a bridgeman, and where a confectioner had for upwards of the 20 years used for the purpose of his business. Confectioner means a person who prepares the candies, cookies, and chocolates, and he is having the machine which is run with the pestles and mortar in his back premises which abutted on the garden of the physician. Then a physician has constructed a consulting room very adjacent to it. And the noise and vibration were not felt to be a nuisance complaint until 1873. Before that one, there is no noise, no vibrations, no pollution would be there. Noise pollution, I mean to say, was there. But after the construction of the consulting room by the physician, then he found the nuisance from that day onwards. So here the point say, when the physician erected a consulting room at the end of his garden, and then the noise and vibrations were going to be increased proximity because a nuisance to him, which became a nuisance to him. The question for the consideration of the court was whether the confectioner had obtained the prescriptive right to make the noise in question. Suppose if he enjoyed more than 20 years, there was no such a nuisance, but whenever the physician constructed a consulting room adjacent to the factory, at that time he felt there is a nuisance. So it was held that in such matter, so capable of the prevention by the owner of the servient tenement and was not actionable until the date when it becomes by reason of the increased proximity a nuisance in law, and under these conditions the latter had no power of the prevention. There was no prescription by the consent or acquiescence of the owner of the servient tenement. So suppose the confectionery is there already 20 years back, so law of prescription will come out. But at the time, he did not feel any nuisance. But when the physician constructed a consulting room very near or in his own land or proximity to this factory, confectionery factory or unit, at the time that he is feeling the nuisance. The nuisance starts from that time only when it become a nuisance to you. So law of prescription will not come into the picture over here. Let us see what are the defenses to the nuisance. Yes, there are two valid defenses of the nuisance which are as follows. One is prescription. Here, prescription means suppose if you enjoyed the land without any interruption for the 20 years or more than 20 years, at that time you have the legal right to do so or use such a land. Suppose you are using that land more than 20 years to the way to go to your home. At that instance, after 20 years, nobody could stop you not to enter into the premises. Nobody could say so to you because the law of prescription will come into the picture. So that is the same thing which is given. Section 26 of the Limitation Act and Section 15 of the Easement Act. And the prescription is something of kind of special defense because if a nuisance has been openly and peacefully carried out without any interruption, in that case, the defense of the prescription can be used. Suppose you are keeping the car in front of your house or adjacent to your house. More than 20 years, nobody has made an objection. And after the 20 years, if anybody makes an objection, then we will say that it is not amount to nuisance because defense of the prescription come into the picture. The nuisance is considered with the legal as if it had been authorized in its commencement by grant from the owner of the land when the period of the 20 years has been expired. Suppose if you enjoy the premises and keeping your car parked over there more than 20 years later on, even the owner of that area where you parked your car cannot ask him to vacate it, or you make him to not to keep the car in that place because he enjoyed more than 20 years without any interruption peacefully. So law of prescription is a good defense. And Iliaston versus Fetham, this is another case law. It was held that a prescriptive right to the exercise of the noisome trade on a particular spot may be established by the showing 20 years user by the defendant. See, suppose if he is having like a pestle and mortar mill, at that instance, the voice is as usually be continuously coming over there. It is more than 20 years. Suppose if he added another, what is a pestle and mortar mill or a motor, then the voice which are the decibel, particular decibels are there, then that will be increased. When the increased would be there, then it becomes a nuisance to the adjacent locality. Otherwise, a small nuisance one can tolerate it. Suppose if you are having the floor mill adjacent to your house in the residential locality, generally it produces a little sound, and that sound you can tolerate it. But you are not supposed to run at the night 12 o'clock because the night sound travels more, and you will feel the more nuisance over there in the night because your sleep will be disturbed. So that was the thing. And next we will see the Mohani Mohan versus, this is another case law. Mohani Mohan versus Kashinath Rai. In this case, right, it was held that no right to hold a kirtan upon another's land can be acquired as an easement. Such a right may be acquired with a custom. Suppose if you are acquired by the customer or easement certain right, later on that you cannot say that it is a nuisance because it is a law of prescription will come into the picture. But in the suggestions in Bridgman, the law of prescription will not be used over there because there also confectioner used his pestle and mortars for the confectionery making. The can is more than 20 years. But at that time that they did not feel any nuisance. But when the physician has constructed a consultant room adjoining to it, then the nuisance started from there. So there the easement right will not be coming to the picture, and the inconvenience caused by the noise and the noise pollution and the dust pollution to the by the air machinery definitely will give a right to the physician, the plaintiff, to bring an action and to see that the injection will be issued. So it was held that the B must succeed. Here the B, the doctor will succeed. A cannot plead prescription because it is having more than 20 years over there. But at the time it is not a nuisance. But when he constructed his consultorium, from that time onwards only the nuisance will started over there. So here the law of prescription will not be applied over there in the suggested man. The next difference is statutory authority. So a statute itself is allowed to make it to so. So at that instance, we cannot claim the nuisance. For instance, we have the very classical case law in this one, that the landmark case law is Wagon versus Tufwell Railway Company. In this, the defendants who had authority by the statute to locomotive engines, at the time the steam engines are there, which will be used as live coal and fire it, the steam, it will run. So on the railway, we are held not liable for the fire caused by the escape of the spark. So in the sparks which is escaped from the chimney, of course, in the chimney there would be a mesh. Of course, if you happen to see the steam engine and you find at the chimney, there is a mesh, and this will not allow a big live coal to come out of the chimney. Only small will come out of it because there is a mesh will prevent it. So even though that small was flying in the air and carried by the air to the adjacent land where the hay was there and which got the fire ignited and the injury is caused to the plaintiff bring an action against the railway company. But the defense of the railway company is that the statutory authority is there to run the rails with the steam in particular area. Of course, adjacent area also they will acquire. Who? Railway company. So it is a statutory authority. Yes. If you say the Ekmode versus Alousa, where a public officer was given a power to clear the inland waters. In exercising the power, he removed some canoes from the water, but in the process of the damage the particular canoe, and the court held that the power to remove the canoe is incidental to the power to clear the waterway, but damaging the canoe is not a part of the power given by him by statute. He was therefore liable for the damage. Of course, the power is given over there to clear it. It doesn't mean that you have to damage the canoe. So that is the another point. If a person having the power to remove it, clean it, but if he damages certain things which is there in the canoe, then he is supposed to pay the compensation. So now let us see that in the case of the nuisance, it is no defense. So nuisance is no defense. What is that? The plaintiff himself came to the nuisance. So at that instance, the plaintiff himself he came to the nuisance. It is no defense. The village versus village of Wilson Villa versus service. The plaintiff, a village, and the government bodies alleged that the defendant's hazardous chemical landfill was a public nuisance. The plaintiff sought enjoin the operation of the landfill and required the removal of the toxic waste and the contaminated soil. The court found that there was a substantial danger of the groundwater contamination and explosion from the chemical reactions. Although the damages were prospective, the nuisance already was present. Therefore, the court granted the injunction, ordered the site to clean up. So here the a land, it is hazardous chemical factory is there, and already existing over there, and it is amount to the nuisance. The reason is if it is escape from that place and causes an injury to it, they should not supposed to say that you came near to the nuisance. Of course, they are there. already living, and the factory is what I say extended over there, then it will be close to become the residential locality. At that instance, we cannot say that you came near to the nuisance, so it is not a defense. Means the company should have to pay the compensation. For instance, if you are in the firecrackers, when you are making the fire cracking, and because people will enjoyment will come and look at how it will be exploded. Suppose if one rocket instead of going vertical, it go in the tangent way, diagonal way, and cause an injury to you. At that instance, you cannot say that you came to the nuisance because you are supposed to take the particular precaution standard, and you have to burn the crackers in a systematic way. Otherwise, you should not say that you came near to the nuisance. That is not a defense. That is coming to a nuisance. Just now I give an example. An example of the coming to nuisance occurs when someone moves into the property near an airport or industrial complex, and then complains of the nuisance that existed prior to his moving here. At that instance, you coming to the nuisance is no more a defense. Of course, here they have given the conditions for that one. This cannot be taken as a defense when number one is coming to the place of the nuisance. Number two, that the act causing the nuisance is beneficial to the public. Number three, the place where the nuisance is created is the only place suitable for the purpose. Number four, that the defendant is merely making a reasonable use of his property. Number five, it is no defense that the defendant's operation would not alone amount to nuisance. That is the example. The other factors contribute to the smoke complaint. So these are the five factors we can say that where the defense of the here what the defense is given here the plaintiff himself came to the nuisance. So it is no defense, we can say, because these conditions are fulfilled over there. We can say it is no defense. Of course, here is given some of the points that is plaintiff came to the nuisance. What we say, if a man knowingly purchases an estate in close proximity to smelting works, his remedy for nuisance is created by the fumes issuing therefrom not affected is not a valid defense to say that the plaintiff came to the nuisance. Actually, if it causes a nuisance to you, earlier it was not a nuisance, but now it is becoming a nuisance to you, then definitely we can say that you came to the nuisance is not a defense. In case of the continuing nuisance also, number two, it is no defense that all possible care, skill and being used to prevent operation complained of from amounting to a nuisance. So here, can you read number three? Yes,
It,
unmute and read number
it,
three.
it is no defense that the defendant's operations would not alone mount to nuisance. Example, the other factories contribute to the smoke complained of.
Yes. See, other factors are contributed for the nuisance would be there. At that instance, they should not say that, see, my factory only not made it out, the nuisance to you. Other factories, smoke also coming to you. So, first you have to defend yourself. Why such a thing will coming out of you? So, alone amount to a nuisance. Your factory itself is amount to a nuisance. Forget about the other factory. In the other factory, will file a separate case regarding the nuisance to them to get the compensation. Number four, it is no defense that the defendant is merely making a reasonable use of his own property. No use of property is reasonable, which causes a substantial discomfort to other person. Suppose if a person says that, no, I'm using very much care and we are taking a lot of care that the nuisance will not be caused to the adjacent locality. Answer is no. The answer is you are not supposed to keep the stable, means horses in the residential locality. However, that you make a lot of care also, but still it is amount to a nuisance. So that's why number five, number six, they are given. So it is said to be the nuisance, but you should not say that it is not a nuisance because you came near to the nuisance. Number one, number two, and we have taken a lot of care over there, so nuisance will not be created. Number two, and that's why number one to six, that it is nobody defense to say so. The last one, six, will it be see it. That the place from which the nuisance proceeded is the only place suitable for carrying on the operation complained of. If no place can be found where such a business will not cause a nuisance, it cannot be carried out at all except with the consent and acquiescence of the adjoining proprietors under the authority sanction. Suppose where you are carrying the business, there it is a nuisance. Suppose if the same business will carry at the faraway places, it's not a motor nuisance. So that is so it is not a defense to say that you are very near to the nuisance, hence you could not get it. So let us see the remedies for the nuisance. Number one, injunction. So suppose somebody is causing the smoke every time the smoke, morning till evening, none even night also. At the time you ask that a injunction would be issued over there, not to cause any other such a thing which is continuous over there. So injunction will be issued against him. So the granting of an injunction is against the discretion of the court. Of course, here the discretion of the court is taken to consideration whether to grant a temporary injunction or grant the permanent injunction. So the second remedy is damages. I told you the pollutant pays. Suppose if a person is substantially suffered over there, then the pollutant will pay the damages to him or to her or to the company or the group at large. So that is the damages, is the second remedy. And third remedy is abatement, means removing the such a nuisance from there. That means the summarily remedy or removal of the nuisance by the party injured without having a recourse to the legal proceedings. It is not a remedy with the law of the favor, it is not a usually advisable. The plaintiff himself cut off the branches of the tree of the defendant, which hangs over his premises and causes the nuisance to him. Suppose somebody's branches is protruded in your land, like let us see that the neem tree branches protruded in your land. At that instance, you will ask him to cut down because you are it is a threat to his house. Number one, number two, the lot of falling of the leaves and even the neem fruits also causing a nuisance to them because their what is the front yard is very much clean, the back yard also equally very much clean. At that time, they can ask you the person to cut off. Suppose if he did not cut off, you can cut off the branches which is protruded in your land. That is the one. So that is abatement means removing the nuisance. Suppose if it is a mango plant, and the half of the mango branches are protruded in your land. At that time, whatever the mangoes would be there falling in your land, you are the owner of the mango. Am I right?
Yes, sir.
See, you can enjoy the mangoes because it fell down in your own premises. At that time, you can enjoy it. At the time that you don't ask him to cut down. Suppose if you ask you to cut down, your children will not keep quiet. They say, Dad, why you are saying? Because we are enjoying the mangoes. So that is the thing where we can make. Of course, nuisance and trespass distinguished. How the distinction would be there in the nuisance and trespass. So trespass means direct interference would be there. Trespass, on one hand, it is a direct physical interference with the plaintiff's possession of the property through some material or tangible object, whereas some material or tangible object would be there, whereas in the nuisance, it is not an injury to the some right of the possession of the property, but not the possession itself. So he cannot enjoy the property over there, but is not directly to the possession of itself. So that is the number one. And number two, trespass is actionable per se. Suppose somebody entered into your house, even though there is no damage caused over there, but still you can say that you are a trespasser, you will be prosecuted and you will be penalized. Or you are to pay the damages for that regard. Even though nothing loss is come across to you, if you just supposed to treat on your land. But whereas in the case of the nuisance, only the proof of actual damage to the property is required. So the proof of the actual damage should be there. It's not actionable per se. So that is the distinction between the nuisance and trespass. Example: simply entering into another's individual property without the owner's consent and without causing him any any injury would be trespass. Whereas if there is any injury to the property of another or any interference with his enjoyment of the property, then it will amount to a nuisance. For the enjoyment of the property is concerned, it is a nuisance. Interfering in somebody's land, it is a trespass. Then, if the interference with the use of the property is direct, then the wrong is trespass. Whereas if the interference with the use of enjoyment of the property is consequential, it will amount to nuisance. When it is a direct, it is a trespass. When it is a consequential, it is amount to nuisance. Example: planting a tree on someone else's land would amount to a trespass. Suppose you cannot have the right to plant the tree in somebody's land, it's the amount of trespass. Whereas, if a person plants a tree on their own land, but which then outgrows to the land of another, would amount to a nuisance. Suppose the land where you planted the tree. When it is grown over there, the branches protruded in the somebody's land. Then when protruded on somebody's land, then it is amount to a nuisance. Of course, here he has given Usha Ben, Navin Chand Trivedi versus Bhagyalakshmi Chitra Mandir. Again, the case law is given over there because if you hurt your own feeling, you are not supposed to see such a movie, but it is not hurting to the everybody's feeling because whatever the is synchronized over there of the three goddesses are jealousy to each other, and hence the Parvati, Saraswati, and Lakshmi, jealous of one another, were ridiculed in the film. It was held that there is no hurt to the religious sentiment, and hence it is not actionable. Of course, here point wise is given the distinction between the nuisance and the trespass. Can you read the first one? Trespass is, can you read?
Trespass is direct physical interferences with the plaintiff's possession of land through some material or tangible object, while nuisance is an injury to some right uh, accessory to possession but no possession itself.
Yes. So direct interference is trespass, or consequent interference is the enjoyment of the position is nuisance. So, like an example, a right of way, a right of light is an incorporeal right. That means intangible right. That is, what do you say, intangible right? Intellectual property right, like the intangible thing it is. Incorporated right over the property, not only to the position of it, and hence disturbance of it is the nuisance and not a trespass. Suppose somebody will hinder your way, or somebody will hinder your light, at the time it is not a trespass, it is a nuisance. And trespass is actionable per se, as I told you, and where the nuisance is actionable only on the proof of the actual damage. It means trespass and nuisance are mutually exclusive. So they may overlap when the injury is possessory as well as to some right necessary position. The trespass of a cattle discharge of the noxious matter into a stream and ultimately to another land, then it becomes a nuisance. So here, if interference is direct, the wrong is trespass. If it is consequential, this is the amount of nuisance. Like I give the same example: planting a tree on another's land is a trespass. You are not having a right to plant a tree on somebody's land. But whereas you can plant your tree in your own land, but when it is grown up, the branches protruded or projected in your neighbor's land, then it becomes a nuisance. Is it clear?
Yes, sir.
So, in the conclusion, what I want to say is the law of nuisance is almost an uncodified one because there is no codification would be there. These are called nuisance, these are called not nuisance. Because it is a judgment law, only cases will decide it, which is a nuisance, which is not a nuisance. Yet it has grown and expanded through the interpretation and through the then the plethora of the judgment means a lot of judgments would be there to where we can make it out whether it is a nuisance or not. The concept of the nuisance is one that arises mostly common in a man's daily life, and the decision regarding the same has to be delivered in a case-to-case basis, ensuring that neither the aggrieved plaintiff goes back or uncompensated, nor the defendant is punished unnecessarily. So, Indian courts in the matter of the nuisance have borrowed quite intensively from the English principle as well as from the decisions of the common law system, along with the creating their own precedents, like we're following the justice, equity, and good conscience. Also, they will use it to see whether the damages should be awarded or not, in addition to following the legal principle, legal maxims, and the cases of common law as well as the English case law. So, this has resulted in a sound system of law being developed that ensures the fairness and well-being of the all, that is the parties to the society at large. So, the concept of nuisance arises commonly in everyday's life, though in fact, Indian courts have borrowed the quite lot of from the English principle, as I said before. And the nuisance arises whenever a person uses his property to cause material injury, and like that, odors, dust, smoke, other airborne pollutants, water pollutants, hazardous substance, noxious toxic gases have all been held to be the nuisance. Under both the private and public nuisance law, the plaintiff must prove that the defendant activity is unreasonable, interfered with the use of enjoyment of the protected interest, and caused the plaintiff to substantial harm. So, can you read the last paragraph?
Plaintiffs may bring a public nuisance action if there are damages, interference, or inconvenience to the public. A state may assert a public nuisance action as an exercise of its police powers of the typical situation. A private citizen may bring a public nuisance action only if he or she can show that he or she has suffered from harm that can be distinguished from the that suffered by the members of the general public.
See, sometimes
So
what will happen? A public nuisance also you can bring an action against the public nuisance when you have suffered more than the other people. If you show that, then you can get the public nuisance also. We turn into the private nuisance and you will get the damage. Yes. So that is the whole thing. And this is my permanent address. But in yesterday class, I told you the gargoyle. I don't know whether you remember it or not. Yeah, this is the gargoyle. Can you tell me what is that? See, some fish or animal or some head is there. Is it not?
yes, sir.
Yes. Can you tell what is the purpose of keeping such a thing? Especially in the old buildings, if you happen to see it, the roof water will flow through their mouth and falls on somebody's land or in their own land. Have you seen any time such a thing? In the old buildings, you will find it. In old structures and edifices that you will find such a gargoyle. But nowadays, if the roof water wants to falls down, what do? You use the pipes. You use the pipes. That pipes will from there it will go into the sump. It will store the water also. So this is the gargoyle. Suppose if you keep the gargoyle on the adjacent land aside, when it is rains, definitely the water will fall in the
Fall in the
adjacent land.
float.
Suppose if this gargoyle is protruded with the pressure of water, it will fall means it will go like this. Then it will reach the adjacent land. Then it is able to directly trespass, or directly we can say it is a nuisance we are created over there. At that instance, we can say this is the anticipatory nuisance. Means if not today, tomorrow. If not today, tomorrow. Tomorrow that it is going to be, if not today, tomorrow it is going to be rainfall, then the water will be there and which will be wet and which causes a nuisance to the adjacent land. So this is the one thing that I want to make it out. Then another thing which I want to share with you is like this. See, this also potato scarcity. So when there are potato scarcity would be there, then naturally potato will be sold in the fair shops, the ration shops. So during the scarcity of the potato, long queues were made outside the defendant shop who having a license to sell fruits and vegetables. So even he is having a license to sell it, such a thing. So and fruits and vegetables used to sell only 1 kg for the potato per ration card. So the queues extended on the highway and also caused some obstruction to the neighboring shops. The neighboring shopkeepers brought an action for the nuisance against the defendant because the long queue obstructed their ways and no customer is coming over there because of the long queue. Which one of the following decision will be correct? And you say, read the number A.
The
Read the
defendant
number
was
A.
liable. B. The defendant was not liable for nuisance. C. The defendant was liable under the practice of a strict liability. D. The plaintiff's suit should be decreed in his favor.
Yes, which one is the right one? See, there is a scarcity of the potatoes, and the potatoes will be sold in the the fair price shop. 1 kg per potato for the ration card. So there was a big queue was there. The big queue has reached to the on the adjacent area where the shops are there, and they are obstructed their customer to enter into the shop. So now four options are given over there. Which option is correct? Yes. Even though it is wrong, you can try. Good luck.
Sir,
Even though it is wrong, doesn't matter.
C, sir, the defendant was liable under the principles of strict liability.
No. The reason
Is it?
is B, the defendant was not liable for the nuisance. See, there is a scarcity of the potatoes. So the government thought they said, okay, per kg, one potato on the ration card we will send you, and they kept it in the fair price shop. So in the fair price shop, there is a long queue would be there. So once the scarcity will be out, do you think that the queue would be there?
No.
See, once the scarcity is over, there is no necessity 1 kg per ration card potato will be sold because potatoes are available even on the payments also.
No scarcity, sir.
Though it is not a nuisance because of necessity only they made a queue, and after the queue it become not a nuisance for there because there is no space to stand and people very lengthy is there. They obstructed the way of the other customers to enter into some other shops. But anyway, that you can say excuse me, then you can pass on also. But it is not about the nuisance. The defendant was not liable for the nuisance. That is an answer. Same thing here. Another case will also come the same way. Onions are shortage is there, something like that. So here is another situation where we can make it out. So let us see that what is the situation. Onion shortage, same thing will be applied. Then factual situation we will see in one of the whether it is amount to nuisance or not. At any time it will be closed. By that time I can continue. X and Y are the owners of the adjoining flats. Okay. They are the owners of the adjoining flats. Good. X leased his flat. X leased his flat to R. One R. An AIDS patient. One R is an AIDS patient. Who is R? R is an AIDS patient. So for the AIDS patient that he has given the flat for the year. And fearing the spread of the disease, why tenant vacated his flat? Another why is there tenant who is vacated his flat. Since then, no tenant is ready to move in the vice flat. So vice flat, nobody is coming over there because of the X flat. The AIDS man was staying over there. So why repeatedly requested to X to change his tenant, but it was no use. Now why has filed a suit against X for causing the private nuisance? Now you tell me. Which one is right? Here I have given. Read number A, B, C, D.
Yes, sir. Why will
Yeah, just I want to explain. Yes, now you read. Now you read. Is it visible?
no, sir?
Yeah, because it is the size is very much small. It's gone. Yeah, now.
No, sir.
Yeah. Number A. A will win the courts as X has knowingly caused him financial loss. B. You will fail in his case. X has a right to put his flat to any use as per his choice. The correct answer is Y's claim will fail as X could not be held responsible for wrong belief and the notion of the people. That is the right answer. Because suppose somebody is a AIDS patient was there, it doesn't mean that if you enter over there, you will get the aid. If you touch over there, you will get the aid. But he is somewhere and you will be somewhere, there you should not ask that the nuisance is created over there. Because the AIDS patient is taking the treatment by staying in the locality. So that was the answer we can say. So now the time is up. It's going to be up, and tomorrow there is exam. But the nuisance that I covered over there, I don't know whether the people are interested. Then I will continue.